Hello, my name is David Paez. I will be talking about intellectual property rights. I'll discuss the different types of IPs, cases disputing intellectual property rights, conflicting views of intellectual properties globally, and the ethical issues that come with intellectual property rights. So, what are intellectual property rights? Intellectual property rights are the rights given to people over creations of their minds. Usually, they give creators an exclusive right over the use of their creation over a certain amount of time. There are four different types of intellectual property: patent, trademarks, trade secrets, and copyright. Patent is the right to exclude others from making your product. However, you must disclose how you created said product. After patent runs out, people will have the ability to create your product as they wish. There are two different types of patents: utility patent and design patent. Utility patent protects the way a product works, while design patent protects the way a product looks. Trademarks are recognizable signs, symbols, designs, and words representing a company, product, or service. Examples of this would be Coca-Cola, which is widely known, Apple, which can be easily identified by the Apple logo, and McDonald's golden arches. There are plenty of other popular trademarks that you can probably identify. Trade secrets are a secret device or technique used by a company in its manufacturing its products. Supplier relationships, customer lists, and knowledge about how certain software works can also be considered trade secrets. These are essentially free to protect, but once the secret is out, then there is no way of protecting it. However, you must consult a professional to make sure, however, that you're protecting it is proper and will meet whatever state law it applies to. Copyright is the exclusive right to print, publish, record, etc. You can use copyrighted material as long as you read the permissions of use. Sometimes one may have to request licensing in order to gain additional copyright permissions. Copyright comes with the author and lasts their entire life plus a number of years. I will now discuss some legal cases that highlight important aspects of intellectual property rights. Amazon versus Barnes& Nobles. In 1999, Amazon had sued Barnes& Noble for using a similar one-click technology. Both companies had a feature that allowed a user to make a purchase with one click of the mouse without having to re-enter shipping and billing information. Many critics have argued that the patent gave Amazon an unfair monopoly on what amounts to little more than an efficient means of using standard technology. Critics point out an important risk that companies might make their shopping systems deliberately less efficient to avoid infringement, which ruins e-commerce. The companies settled rather than going to court, which would have provided more insight on important and highly controversial areas of e-commerce law. A&M Records versus Napster Incorporated. Napster was an early peer-to-peer file sharing system. It could be used to transfer various files, but it gained popularity mostly as a way to share music through MP3 files. However, major record companies had an issue with the large-scale distribution of their music for free and sued Napster for direct, contributory, and vicarious infringement of copyright as a way to protect their intellectual property. The court found that although users of Napster chose to share the legal copies, Napster essentially harmed potential album sales. Napster was found guilty for the contributory infringement claim due to the fact that Napster knew the widespread infringement happening on its platform and did not take any action in reducing it. This was a landmark intellectual property case because it concluded that services like this could facilitate copyright infringement, but they are still shielded from any liability due to the fact that it was the users that chose to share illegal copies of protected works. Cybersitter serves as an example of a small American company fighting back against foreign countries violating intellectual property rights. Cybersitter filed a $2.2 billion civil action against the People's Republic of China, two Chinese software makers, and seven major computer manufacturers for misappropriation of trade secrets, unfair competition, copyright infringement, and conspiracy in connection with their distribution of Green Dam Youth Escort. Green Dam Youth Escort is a program used by the Chinese government to filter content for Chinese citizens by blocking those websites they find politically controversial. Cybersitter alleges that Green Dam stole 3,000 lines of code from its content filtering software and planned to distribute 56 million copies of the stolen software throughout China and to Chinese speakers. Cybersitter stands to be one of the few cases where people actually confront the possibility of their intellectual property being infringed upon by China. No Chinese representative came to court to dispute this, and the tech companies decided to settle, but People's Republic of China did not. They argued immunity from the suit through the Foreign Sovereign Immunities Act, but were ultimately found in default for failing to respond. This case not only shows the global impact of intellectual property rights, but also validates code as an intellectual property. When it comes to intellectual property rights on a global scale, it is a little bit more hectic due to conflicting laws and changes. The US government's Office of the United States Trade Representative, USTR, monitors intellectual property rights around the world and fights IP theft. The USTR evaluates countries and rates them depending on how they enforce IP rights. The USTR issues an annual review called the Special 301 Report, which reviews the global state of intellectual property rights protection and enforcement. As of 2017, the current countries on the priority watch list are Algeria, Argentina, Chile, China, India, Indonesia, Kuwait, Russia, Thailand, Ukraine, and Venezuela. China has been on the watch list before and continues to be on the list not only because of the IP theft and counterfeiting, but also the practices the government partakes in that severely restrict the market for foreign goods. Countries can get off the watch list by taking measures to reduce IP theft, like Czech Republic, Hungary, and Poland have, because they took significant steps in stopping piracy and counterfeiting. The Agreement on Trade-Related Aspects of Intellectual Property Rights, commonly known as TRIPS, has contributed greatly to the expansion of intellectual property law. The TRIPS Agreement obligated members of the World Trade Organization to establish and enforce minimum levels of copyright, patent, and trademark protection within their jurisdictions. Countries that fail to do so will acquire trade sanctions administered by the WTO. Leaders of the developing countries argue that the TRIPS agreement reflects and perpetuates a form of Western imperialism, noting that most owners of intellectual property, copyrights on movies, patents on pharmaceutical products, and trademarks of multinational food and clothing companies, reside in developed countries. These officials argue that strengthening intellectual property rights unfairly raises the prices paid by the consumers in the developing world. Accordingly, developing countries generally have been slow to implement TRIPS. However, some economists state that the long-term effect by stimulating the long-term effect of the agreement will benefit developing countries by stimulating local innovation and motivating foreign investment. Despite the existence of TRIPS, global rates of piracy of software, music, movies, and electronic games remain high. A steady increase in the economic and cultural importance of intellectual property rights can be seen by the strengthening of intellectual property laws. Pharmaceutical companies have used their patent rights to charge high prices for their products, enabling them to cover the enormous cost of developing new drugs and making considerable profit. Developers and distributors of computer software insist that they are only able to remain in business if they can protect the unauthorized reproduction of their creations. The biotechnology industry argues that if they cannot stop rivals from imitating their creations, then they would not be able to recuperate from their costs and would have no incentive in research and development for scientific breakthroughs. Some critics argue that it is immoral for pharmaceutical companies to use their patent rights to set prices for their AIDS drugs at levels that cannot be afforded by most people in Africa and Latin America who are afflicted by this disease. There are a couple of theories that spark debate on the growth and importance of intellectual property rights. Utilitarians believe intellectual property rights should be regulated and creators should be given legal control. They believe that since creators are not given control, other people can illegally reproduce their creations and stifle creativity and competition. Another theory was inspired by the writings of John Locke and his thoughts on property rights. Supporters of this theory suggest that a person who labors upon unowned resources has a natural right to the fruits of his efforts, and that the state has a duty to respect and enforce that natural right. This theory is especially strong when considering items like music, books, and simple inventions. Furthermore, there is another theory that grew loosely from the writings of Kant and Hegel, that artists should enjoy certain moral rights. This approach is based on the idea that private property rights are crucial to the satisfaction of fundamental human needs, among which is the need for creative expression. Finally, the last theory states that intellectual property rights can and should be shaped so as to help foster the achievement of a just an aesthetically sophisticated culture. Advocates of this approach emphasize the capacity of copyright patent and trademark systems, if properly crafted and limited, to promote a vibrant democracy and participatory and pluralist civil society. In conclusion, intellectual property rights are shown to have a cultural and economic importance. Intellectual property rights seem to flourish in developed countries, but may prove to be a hindrance to developing countries like Africa and Latin America. And IPs protect the ideas of individuals while also promoting creativity and competition. Thank you very much for listening to my presentation. Here are my credits. Have a nice day.